Because if you don't do it right, I'm not going to give you any leeway on that. We've already talked about this. One more time, Mr. Renfro, are you sure that you do not want to speak to an attorney about this matter before you move forward?
I'm sure. Actually, I do not have my discovery for the case. I haven't been able to go over the evidence. It has not been served to me. I do not have the police body cams that I've requested a long time ago. I paid for half of them. Have not received them. Have not been able to go through any evidence where they're trying to get me on crimes before the initial stop was a civil infraction and somehow bred a crime out of that. It's an unarrestable offense, the civil infraction. You cannot, that's fruit of the poisonous tree. So now we're here on crimes and taking care of the initial problem. So the tickets have to be first. And we're not moving anywhere until we get that clear. And you're in improper jurisdiction. Subject matter jurisdiction, and personal jurisdiction. And we're not gonna move nowhere until we get this taken care of. I demand this court to vacate these matters. I say vacate, you say dismiss. Vacate these matters immediately.
Done? One, I've already said that I'm not going to vacate, and dismiss is the right word. I already said that. Two, I've already said that jurisdiction is appropriate. We have subject matter jurisdiction in this matter. We also have personal jurisdiction. Subject matter jurisdiction is because you're in a criminal court in the state of Michigan, and that is what we are dealing with. In fact, it's a misdemeanor, so you're in the right criminal court being district court, so we have just subject matter jurisdiction. We have personal jurisdiction over you because it alleges that this matter happened in Burton, and Burton is in the jurisdiction of the 67th District Court. So we have both personal and subject matter jurisdiction. Those issues are laid to rest. If you want to bring them up again, you can bring them up on appeal. You will not bring them up again in this hearing because we are getting ready to start a jury trial, and those are issues that are not appropriate to bring up in front of the jury. And as far as your issues of civil infractions leading to misdemeanors, happens all the time. All the time. And it is legitimate as established by our Supreme Court. So you can say that if you want to, but your argument is inaccurate. Once again, Mr. Renfro, your argument is inaccurate. You didn't answer my question. My question was, do you want to speak to an attorney before you move forward?
I'm a competent man.
It's a yes or no?
Lawfully competent man, no.
No. The answer is no. All right, I've asked you that question many a times now. I don't feel like I need to ask it to you anymore. You've established very clearly that you're going to represent yourself in this matter, for better or worse. Attorney Stolman, do you have anything that you would like to say in regards to any of the issues that Mr. Renfro has brought up?
Judge, I know he has not made a demand for discovery or request for discovery. I'll give him another copy of the police report. It's the only thing he's asked my office for. I'll have another copy. I believe he has made a FOIA request to the city regarding documents. I don't know whether or not that request has been granted, but I don't believe the FOIA request was all relevant to this case. I believe it was for more documents.
And I believe, Mr. Renfro, you've stated that on the record previously, that the body cams, or whatever those were, that you FOIA'd them. The prosecutor's office is required to turn over to you all of the evidence that they have and all the evidence that they plan to use, and they have done that. We've had discussions about discovery numerous times. We're not going to delay the trial any longer. So we're going to have this trial today. Okay.
We have no exhibits that we're planning to introduce. We're just going to have the testimony of the officer and Mr. Renfro if he chooses.
Okay. Are you trying to say something?
Is the warrant in here? I don't see the warrant. Or the,
This is the second time you've been given those documents. Do you have the warrant from last time? Or the other time that someone gave you that?
I've asked this court numerous of times for the discovery. I have to have it to fight in the trial. I have to have the exhibits to be able to see what's going on or the moves that were made to get me in this position. So that
Answer
warrant.
the question, Mr. Renfro. The question was last time when they delivered to you the discovery after you refused it. Because you actually said you didn't want it because you were confused about how the court rules work. You got the discovery. Did you get the warrant in that discovery? It's not necessary,
I didn't
just so
get
you
the
know, but I'm
discovery.
gonna make sure that you have it. Do you have it or not?
No.
Okay, the answer is no. So here's what I'm going to do, unless there's an objection. I am going to provide the statements for probable cause as well as warrant and complaint copy out of the file. So Mr. Renfro has that. He doesn't have any complaints about not having it. Mr. Our Attorney Stolman, do you have any objection to that?
No, no.
Okay, all right, so we'll make a copy of that, Mr. Renfro, and I, quite frankly, am pretty confident that this has already been given to you, but we'll make you another copy so that you have it right now. I can copy that. Okay, all right, we will pause on this matter, and we will come back in not too long, and we'll get started on that jury trial.